Hello, everyone, and welcome to today's webinar, The Risk and Rise of Contingent Workers. Freelancers, independent contractors, consultants, outsourced and non-permanent workers are a few ways we describe contingent workers. Many employers like contingent workers because they don't have to pay them a salary. They don't have to pay them benefits. They're responsible for their own taxes. Contingent workers like the freedom to pick their own work. They aren't told how to do their work. They're not told when and where to do it. Their goal is to focus on the results, not where and when they do the work. But contingent classification can be pretty tricky. There's federal rules, there's many state rules. Throw in the economic landscape like recession, labor shortages, or inflation. Oh yeah, and don't forget these change all the time. There's a bunch of state rules that are going to take effect in 2023. So there's a lot to think about. But don't worry, stay calm. We have a team of Littler experts that are here to help you. And we know that this is important to all of you because we had over 2,500 people sign up for this. My name is Michael Worth. I'm the Vice President of ComplianceHR. I've been with the organization since it started 8 years ago. And our goal has always been to simplify the complexity of employment law firm. We serve up Littler's wage and hour content through an artificial intelligence engine so you quickly get the right answers to do your job. I'd like to thank all of you for joining us today. We know it's not always easy to take time out of your busy day, and we greatly appreciate your time joining us today. If you have questions, put them in the Q&A box in the top right. We'll try to get through some of those at the end. Today's presentation will be recorded, and we'll send it via email to ComplianceHR, and it can also be accessed through your Beacon Live account. So, without further ado, I would like to turn it over to the Littler team of experts who are the co-chairs of the Littler Contingent Workplace. Rachel, I'll pass it over to you.
Thank you, Michael. Thank you, everyone, for joining us today. My name is Rachel Fendell Satinsky. I'm a shareholder in Littler's Philadelphia office. I'm here today with my colleagues Mike Gotzler and Josh Waltman. The three of us are the co-chairs of Littler's Contingent Workforce Practice Group. To begin today, we want to talk about the rise of contingent workers. As Michael said, we know this is an issue that is pressing and on many of your minds because of the increase in the use of contingent workers. So to give us a little bit of a sense of how you, those of you on this call, are using contingent workers, we want to start with some polling questions. The questions will come up on the screen and you'll have the ability to answer them. Here's the first question. Does your organization rely on staffing platforms or crowdsourcing for its labor needs? And I'll give everybody a few seconds to answer, and then we will see the answers pop up. Great. So the answers that we have interesting. We have about 53% of the group that uses contingent workers, and we have about 47% of the group that doesn't. Now, not everybody answered, so that's not fully representative of the group. But interesting to know that we, on this call, at least the people who answered, we have about half who are using workers and half aren't, and some folks have commented that yes, they are, or somewhat aren't. I also see the comment that you need some more time to answer the poll, so we'll make sure to get that to you on the next one too. Here is the next question. If you have workers in multiple countries, do you rely on a third-party provider to pay or provide benefits to them? Again, I'll give everyone some time to answer that question. Of those of you who answered, about 42% said yes, you do use a third-party provider or provide benefits. And about 56% of those who responded said no, they do not rely on third-party providers to pay or provide benefits. It's not part of our discussion today at length, but there is a real rise in the use of international contingent workers, and with that, there are numerous considerations that come into play that are different than working with traditional contingent US-based workers. So those of you who are using third-party providers, or even those of you who are not and have contingent workers in multiple countries, certainly issues for you to be aware of as you continue to utilize them and think about how your business can incorporate them in a legal way. This is the third question. Does your organization utilize PEOs, EORs, staffing firms, or other third-party staffing providers? An EOR is an employer of record, and a PEO is a professional employee organization. And again, we'll give everybody a little bit of time. If you're not familiar with staffing firms, we're talking about third parties, so contracting with a third party to provide workers for your company. The results here are about 70% yes and about 30% no. This is also consistent with that rise that we've been talking about. And here's sort of the big question, right, as we talk about the rise. Has your organization's reliance on contingent workers, and when we talk about contingent workers, we are talking about a range of individuals, independent contractors, workers that come to you through staffing firms or other third parties, EORs, platforms, crowdsourcing work. So, for example, if you are posting something, a job on a website that's not your own company's website, PEOs. So has your reliance on contingent workers identified as that group of workers increased since 2020? Of those who answered the question, 62% said yes, their reliance has increased, and 38% said no, their reliance has not increased. I think these numbers are interesting because it really tells you, right, since the pandemic, we all know, we've seen everywhere that there is a desperate need for workers. I think every employer is looking for certain kinds of employers, and specifically in certain industries, there's a real need for workers. And so employers are having to get more creative about how they find workers and how they retain their workers. I will turn over the next section to my colleagues.
Thanks, Rachel. Good afternoon. Good morning, everybody. This is Mike Gotzler. And that polling data really supports what Josh and Rachel and I have been seeing over the last few years, which is, number one, many large employers across the country were already relying on staffing companies, recruiting firms, PEOs, EORs before the pandemic. And secondly, that reliance has only increased over the last 2 to 3 years. One of the reasons why employers look to contingent workforce solutions is because workers are becoming harder to find, right? So we thought it would be helpful to display some of the most recent BLS data, Bureau of Labor Statistics data. And we looked back about 17 years, really to the Great Recession in 2008, and just looked at job openings here. So that's what you see represented on the screen here. And so if you look at February of 2022, we reached a 17-year high for the number of job openings. And really, we're still a year later now in February 2023, still very close to that 17-year high. So related data tells us that nearly 4 out of every 5 employers, that's across all industries, report significant difficulty finding talent. So we didn't bother with a poll question about that today because we know how common that is. This next data point here for us is looking at things from an applicant flow perspective, right? And this is telling us how many applicants are out there per job opening. So you can see the spike from COVID-19 mini recession, if you will, back in February, March of 2020, where for a very brief moment in time, there did seem to be a bit of more availability, right? More applicant flow related to or in relation to the number of job openings. But now we're back to where we were pre-COVID, which is essentially we're looking at roughly less than 1 unemployed person per job opening. So that tells one of the stories, one of the main reasons why we've seen an increased use in contingent workforces and related providers. So if any recruiters are on the phone and are on the call, we know there are many of you, you all know that just because you have applicant flow doesn't mean that you're going to be able to fill your open positions. And ghosting has become, quite common. We've got some interesting data here that shows really just how prevalent it is, and it's fairly startling. 84% of respondents to a pretty broad survey of job applicants and employees found that at least once in the last 18 months, 84% of respondents had either ghosted a potential employer or had ghosted a current employer, meaning they were up for perhaps a promotion or transfer and just were no-shows. That is shocking data, and we thought we'd present it to you here. So, and there, of course, are different reasons for ghosting, but the long and short of it is when there are so many job openings and so few applicants, and applicants have that general awareness of the imbalance between applicants and job openings, you're going to see more ghosting. There just isn't that same type of leverage we see. So one of the other polling questions that Rachel took us through was related to international workers, right? And so when workers in the U.S. are so difficult to find, many organizations look overseas or out of country to fill their labor needs. And that's something we've continued to see heavy reliance on by U.S.-based employers as well, looking to workers and EORs outside of the U.S. to find that labor that they need. And yes, we have limited time to address international worker issues, as Rachel said in the outset, but just a couple of really high level items to keep in mind. You know, the U.S. labor laws are very unique. And once you get outside of the United States, things look very different, right? And so we know from the polling results that we just shared with you that many of you are aware of that. For those that are just dipping your toe in the international worker space outside of the U.S., you know, just high caution here. Every jurisdiction is unique. Just because one country's in the EU doesn't mean, right, that a neighboring country in the EU is going to have similar employment laws. It's really critical that you know where your workers are. And that's true whether you're paying them directly or whether you're relying on an EOR or a PEO, for example, to compensate those workers. It's still worth your while to know where those workers are in the event that a foreign jurisdiction determines that your organization, you know, has some sort of employer obligation to those workers. So this slide here references the use of PEO arrangements outside of the U.S. Again, PEO laws are very different, just like employment laws are very different outside of the U.S. The same is true as it relates to PEO regulation. And in fact, the terminology is very different. And generally speaking, PEOs are largely a U.S. Legal construct, and employers of record, or EORs, are much more common outside of the states. So we're happy to talk with any of you if you've got questions about how to structure those types of work arrangements outside of the U.S. With that, I'm delighted to turn things over to my colleague Josh, who's going to start our discussion about some of the risks of partnering with contingent workforce providers.
Thanks, Mike. So we could choose from a number of different risks that are present with contingent workers, whether it be ICs or different types of contingent workers. And we have selected a few that we are seeing a lot of activity on. The EEOC issues strategic enforcement plans. I think it's every 4 or 5 years. And the last time they listed 5 points of emphasis, and one of them was contingent workers. They phrased it as temporary workers, staffing agencies, ICs, and the on-demand economy. So this is, of all the areas of emphasis that the EEOC could choose, contingent workforce is one of them that they've highlighted. And that's sort of backed up with some samples here, sample settlements. A lot of these involve staffing agencies or third-party recruiters. And you can see that the EEOC is bringing actions and getting some high settlement dollars out of sex discrimination or harassment cases or other protected categories. The EEOC's framework for this is that if a charging party files an EEOC charge, they're going to assess whether they were an employee of the respondent. And if in the case of a staffing relationship, it's possible that both the staffing firm and the client buying the labor are joint employers. The EEOC has long used a multi-factor test called the Darden test, which you might be familiar with. The Darden test actually draws from a number of different factors, including control, direction and control of when, where, and how the work is performed, the skill, the tools, the continuing relationship, the duration. So I'm not going to go over all the factors because we're pretty familiar with those factors, but the Darden test uses about a dozen factors. And so what we find when we're litigating this is if you have done a good job of implementing best practices and you give us some really good factors, such as, hey, they can accept or reject work, they control their own schedule, they can hire their own workers, even if you don't hit on 100% of the factors. If you give us these opportunities, we can make an argument that the host client is not the joint employer. Obviously, the EEOC has an interest in finding and exerting its jurisdiction. And so sometimes what we find is when we're making this argument to the agency, yes, we argue the factors, but they also want to know who was the bad actor. And if your manager as a client of a staffing firm was the bad actor, we're less likely to get out to prevail on the joint employment question. The EEOC is more likely to assert its jurisdiction because they want to right the harm that's protected by Title VII, ADEA, ADA, the other statutes that they enforce. And so one area that this comes up in is the reasonable accommodation areas. And staffing firm clients of ours often call us to consult to say, we've got a qualified candidate, they need an accommodation, but my client is just sort of outright rejecting that. And this advice goes for both the staffing firm and the client. It's in both of your interests to work together on reasonable accommodations. We do advise that as a best practice, the employer, so in this instance, the staffing firm's W-2ing the worker, the employer, take the lead on the interactive process. Go ahead and gather that information about workplace restrictions, explore possible accommodations, and then go to the client and say, this is what the individual needs. And in an extremely simple example, maybe they're an auto parts store and they need a stool to sit on. Great. That's an easy one. We can all cooperate on that one. On a more difficult example, let's say that you've got a 3-month need, a 3-month window, and you have looked to a staffing firm to help you fill that need. And the staffing firm says, I have somebody, but they're not ready for a month. They need some leave. Well, again, this isn't legal advice. We need to know the exact facts of your situation. But in that situation, it's possible that the client can argue, look, that's not a reasonable accommodation because this is a 3-month tenure, and they'll be gone for a third of that. Or it's an undue hardship, which is a different analysis, but sort of the down the stream a little more argument. But what if the person's not available for 3 days as opposed to a month? A little bit more nuanced. And so these things aren't always black and white. And that's a purposely difficult example that I'm giving you. There's everything from the easy example with giving somebody a stool to sit on to this more difficult example and everything in between. Our advice, again, is that the W-2 employer, in this scenario, the staffing firm, take the lead on the interactive process and then work with the client to see if they can make that accommodation. And be careful of just the, no, we can't accommodate that. Get some sort of reason that that's not reasonable or that that would not fulfill the contract, the position that's been posted. Okay, similar looking slide, but different content here. Okay, so this another way that this comes up is that the staffing agency will get a charge and the client is named as the joint employer, and the client says, your employee staffing agency, the person you assigned to us, never reported this to us. And we actually see this scenario quite a bit. And so what do you have in this situation? You have a client that's been named as a joint employer, and they did not have the opportunity to timely investigate, which includes talking to witnesses, looking at documents, making assessments, either substantiating or not substantiating a claim, and importantly, taking prompt remedial action in cooperation with the staffing agency. Now, you might, at this point in the presentation, be thinking, wow, I'm on a presentation from Littler, and doesn't this, they're telling us to cooperate with the staffing agency and sort of jointly work on reasonable accommodations, investigate these things together. Aren't we creating more joint employment exposure? The answer is no, you're not. You're creating more joint employment exposure by putting your head in the sand and not looking at this. If you're the client, you have an obligation to keep a workplace free from discrimination and harassment. If a customer, a vendor, a staffing worker, an independent contractor walks in and violates that policy and it impacts your employees, you have an obligation to investigate. Now, if the staffing agency employee is the one making the complaint, the staffing agency should take the lead on that investigation, and the client should reasonably cooperate to provide access to witnesses, and we advise that you have an HR rep present for any interviews, and that goes both ways. So if the complainant is an employee of the client would take the lead on the investigation, and if they're going to interview a staffing agency worker, would offer the staffing agency the chance to have an HR rep there for the interview. This, in response to EEOC complaints, is very helpful because you get to investigate in real time, timely manner, and take remedial action. And don't forget that the ultimate employment decisions, such as discipline or even termination, always belongs to the W-2 employer. So if the client determines that a staffing worker violated the harassment policy, they can end the engagement because a part of the obligation is to be compliant with the law in this relationship. We write it into our agreements, but it also is good arguments that that's built into the relationship. So we can end the relationship, but whether to terminate the employee or discipline the employee, that's up to the W-2 employer, the staffing firm. We are getting a lot of questions on investigations and reasonable accommodations right now. So if you want to drop questions into the chat, we're not going to give legal advice because we need specific facts, but if you have general best practice questions, we're happy to address that, and we're also happy to connect with you after the presentation. In addition to the EEOC, one of the other areas of risk that we decided to highlight today, out of many choices, is the new DOL guidance. And it actually has been delayed. It was supposed to go into effect last fall or winter. But this is another example of changes in the shifts of the presidential administrations and the agency's priorities. And so you saw that before the Trump administration, there was the 6 factors. The Trump administration came in. They actually used the same factors, but kind of reorganized it to 2 core factors. And then the Biden administration came in and is in the process of changing it back. And so it's I think it's a lot like the NLRB's shift, where you've got an Obama era policy. The Trump administration came in and made a shift that was a little more friendly to classifying individuals as IC, so a little easier to satisfy that test. And then you're shifting back to a little more difficult test under the Biden administration. So not a surprise, pretty intuitive. The proposed rule would go back to the 6 factors, and they're on your screen there. And we're all familiar with these factors as they pop up in many tests. But one interesting point in the proposed rule that actually would be a bit of a nuanced point, but it is, I said it's a return to the prior rule under the Obama administration. There's actually a little bit of a development where it would actually do something a little different than that, which is they've interpreted the investment portion of this as an entrepreneurial investment. And so not simply just I bring my tools to the job, which to me has always been part of the investment in the business, but sort of in the structure of your business, to hiring workers, to marketing, to investing in technology for your business, things like that. So this kind of entrepreneurial building your business investment is a new point of emphasis if this rule does end up being finalized, still pending right now. Another area of emphasis that we decided to present on is the rise of the ABC test. The ABC test is A, direction and control, B, core business, and C, whether they're an independently operated business. The ABC test is actually used in a number of states that you can see here, but I want to draw your attention to the states that have the 2 asterisks by them. California and Massachusetts use a modified ABC test that is particularly difficult to satisfy, and for unemployment limited purposes, a couple of other states use that modified ABC test with the B factor altered. That's very difficult to satisfy. The reason that's difficult is the B factor is the worker part of your core business, or are they performing work outside of your regular place of business? And so if you're out in the field making sales calls or repairs, you could argue, oh, I satisfy the B factor because they're outside of the place of my regular business. The modified B test takes that part away and says only asks, are they part of your core business? And so it's harder to satisfy. Massachusetts actually was doing it before California made it cool, but California certainly made a lot of noise with the ABC test. The way they did that is that they used a multi-factor test under Borrello, under case law under Borrello, which was no easy test to satisfy and was long lamented by employment attorneys as difficult to satisfy. And we got something even more difficult to satisfy. In 2018, case law applied the ABC test to California wage orders. And then the real big news was that in 2020, January 1, 2020, AB 5 went into effect that broadly applied this ABC test, this modified ABC test that I was just describing broadly in California. So there is an interesting development for those of you on the call that have a platform-based model. There's the Transportation Network and Delivery Network Company exceptions. Those are quite nuanced and detailed, and you have to satisfy the definition of a transportation network company or a delivery network company. And in addition to satisfying those definitions, you also have to do a host of other things to qualify for this carve-out under Prop 22, including providing workers' comp, paying 125% of the minimum wage in the area, harassment training, and so there's about I think there's about 8 to 10 requirements in there. And so it's not as simple as I meet the definition. It's I meet the definition and I'm doing these additional things, essentially providing more benefits to the workers. If you do qualify as a TNC or DNC and you do satisfy those additional requirements, then it's okay to classify those folks as independent contractors. And you don't have to pass the modified ABC test. You don't have to jump back and pass the very difficult Borrello test. And so the TNC and DNC shouldn't be read too broadly, but if you think you might need some context for those, please get in touch with us after the presentation.
Thank you, Josh. Quite a remarkable job there, covering a lot of ground in a very short period of time. Some pretty nuanced tests and changes over the last few years. One of the things we just wanted to flag briefly for attendees today is some really core workplace safety obligations. The federal OSHA Act in particular, this has its own set of definitions for who is an employer and joint employer responsibilities. So we thought we'd just take a moment, flag it for everybody. Under federal OSHA, there's what's considered a host employer or a recipient employer, and then the staffing agency. So in the traditional temporary staffing industry anyway, OSHA is going to view the client of the staffing firm as the host employer and the staffing agency as the other joint employer. So OSHA essentially assumes, and this is quite unique as related to other employment laws, essentially assumes there are multiple employers in the temporary worker industry in particular. And so it believes that the parties have to share control over the workers, or because they do, they also necessarily share the responsibility for the workplace safety of those workers. So even though the host employer, typically the client of the staffing agency, generally has primary responsibility for identifying hazards and complying with worksite specific health and safety requirements, the staffing agency also has a duty to ensure a safe workplace. So you'll see on the slide here a reference to shared training obligations, and that's always been the case under the law. TWI is something referred to as the Temporary Worker Initiative. It was launched by federal OSHA 10 years ago and is intended to provide staffing firms and their clients with some more clarity about that division of obligations and who's responsible for what. So when there's an injury or an accident and a temporary worker's involved, if OSHA ends up inspecting the premises or conducting an audit, for example, they will expect to see some communications between the staffing firm and the host employer, indicating that the parties know who is responsible for what. And so this is an opportunity to work a little bit closer with your third-party staffing providers in particular, and make sure you know who is responsible for what. You know, one of the things Josh mentioned earlier about partnering when it comes to contingent worker requests for reasonable accommodation, the same holds true here, right? And making sure that you have open lines of communication with your third-party contingent worker providers. With that, I'm going to turn things over to Rachel to share a few considerations related to antitrust.
Thanks, Mike. Over the past few years, the Department of Justice has really amped up its focus on antitrust issues and sort of what I would call untraditional antitrust issues. And so generally, antitrust laws are meant to allow competition amongst competitors and to allow for a fair market. And the DOJ has been kind of cracking down on the use of certain kinds of agreements and actions in order to, in their view, allow for a more open market. And so one of the things, you know, that is common when a client retains a staffing agency is that there may be some kind of conversion fee. And by that I mean some kind of fee that the client pays to the staffing agency if the client decides to hire the worker that the staffing agency has provided. And so typically that would be something that's outlined and identified in the agreement between the client and the staffing agency, and can be structured a number of ways. So it can be if the client hires somebody within a certain number of days during the assignment or after the assignment or for a certain number of months, then the client pays a conversion fee. And the conversion fee can also be structured in different ways. It can be a percentage of what the client would pay for the worker, or it can be a percentage of the worker's salary once they come on board with the client, or it can even just be a set fee that the parties agree to. With conversion fees, the DOJ hasn't come out to say they are absolutely not enforceable or you shouldn't have them, but we would really recommend, if you are using a conversion fee in any kind of agreement you have, it's really something that's very good to have legal counsel review to make sure that they are drafted properly and narrowly so as to stay away from the DOJ's antitrust concerns. Where we've seen more questions are no hire agreements. And so those are agreements where the staffing agency or third party involved in the agreement may say, we won't solicit or recruit or bring on any employees of the client for some period of time after our agreement ends. Typically, these have a scope to them in terms of having a time frame, so it's not a forever agreement. And maybe it applies to only certain categories of the client's employees. That said, the FTC, the Federal Trade Commission, and the Department of Justice have both called into question the permissibility of these kinds of agreements. They have taken various enforcement actions, and an enforcement action is something that's brought by the DOJ against a particular entity, and have sought various fines and penalties relating to these agreements. So this is another area, again, where we really highly recommend speaking with legal counsel and I love to talk about these agreements. I'm happy to talk about them all day if you have questions. The more definitive answer that I can give you is on no poaching agreements. So no poaching agreements are sort of two-way agreements where parties agree not to hire each other's employees. So in the context of a staffing agency, the staffing agency would say, client, we're not going to hire any of your employees for a certain period of time. And the staffing agency says, client, we're not going to hire any of your employees for a certain period of time. And we call these no poaching agreements. There have been a significant number of government agencies coming after no poaching agreements, not just in the staffing industry context, but in many different industries, because it does create an antitrust concern. So we see this a lot, these kinds of no poaching agreements that are well-intentioned in terms of, we want everyone to kind of be able to play fairly in the sandbox and keep their own employees. And while they may be well-intentioned, they do cause legal issues and they can cause legal issues. And the staffing industry is an area where the DOJ has focused some of its time and attention in terms of industry focuses. So it is something to be aware of. I'd encourage you to look at your agreements with your staffing agencies, any other kind of managed service providers, to see whether your agreements have this language in them about no poaching, and if they do, to really think about using them and to consult with counsel again, just given the DOJ's position with respect to them. And then the last is non-solicitation agreements. And so typically non-solicitation agreements are going to be permissible as long as they are reasonable in scope. So, reasonable being somebody that actually has formed a relationship with the other entity, and also in time in terms of a definite period of time in which the conduct isn't permissible. It's a little bit different than a no-hire agreement. Again, something to keep your eye out for in your agreements and to pay attention to, given the DOJ and other government agencies kind of increased attention to these areas. Summing up the risks that we talked about, there are many of them, right? If something goes wrong or something goes awry with a contingent worker. And so there are state penalties, there are federal penalties, there are potential lawsuits. Depending upon what happens, there could be workers' compensation issues. So we wanted to give you some examples of state penalties that have arose in this context. A lot of times clients ask us, can you give us an example so we can go back and tell our business folks why we can't do what they want to do. And so these are some good examples that you can write down or take from these slides, when you get in that situation. Suffice it to say, the penalties are really significant and they add up very, very quickly, especially if you're one of those organizations who answers the question about using contingent workers heavily in your business and continuing to rely on them more going into the future. Now that we've hopefully not scared you, but made you more informed about the risk associated with contingent workers, we want to talk about how you can help mitigate that risk. And there are a number of different things that you can do to help mitigate risk associated with contingent workers. Three big suggestions we have are thinking about conducting audits or a business review of your contingent worker population, and we'll talk about that more, eliminating high-risk engagements, and also having contingent worker policies and best practices. With respect to policies, this is really something that I think is geared towards clients that are utilizing contingent workers, whether with a third party or directly engaging an independent contractor. And the contingent worker policies can be very robust or not very robust, but I think they're helpful to organizations to provide sort of a framework about what's okay and what's not okay. And they can address different things like what are contingent workers, what are the different types of contingent workers, what's the difference between a temporary worker and a staffing agency worker and an independent contractor to help educate those in your organization who are working with those individuals. You can include information about time off and who makes those decisions with respect to time off. Also really important is how does your organization go about terminating engagements with contingent workers? The last thing we want is for someone at the organization to say to a contingent worker, you're fired, you don't have a job here anymore, right? That's been sort of fireworks up for those of us that work on these issues from an employment law perspective. So these policies can be really, really useful. If you don't want to use a policy or you don't think a policy works for your organization, the other thing you can think about is having a list of do's and don'ts that you provide with or provide to your managers or employees who are working with contingent workers that kind of has those, here are things to do, here are things not to do. And obviously on that not to do list is terminate a contingent worker or discipline a contingent worker. And on the to list may include things like, making sure that the contingent workers are included in, company lunches and things like that. So I am glad to now pass it on for the other risks.
Wonderful. Thanks, Rachel. This is Mike again. And one of the other core ways to manage your risk as it relates to contingent workers is taking a really close look at your client service agreements with your different providers and partners. And it's worth noting that Rachel and Josh and I and our other colleagues in our contingent workforce practice group are regularly reviewing those client service agreements, whether they're with staffing firms or professional employer organizations, EORs, et cetera. It's a real common component of what our day looks like here in the practice group. So one of the things we just wanted to call out as it relates to staffing firm client service agreements are these provisions that are on the screen here. These are really the core provisions in any client service agreement with a staffing firm. And again, that's whether you're a staffing firm, and I know there are many on the webinar today, or you're a client of a staffing firm. Also, obviously, quite a few of those folks on the webinar today. So you'll want to take a look at W-2 responsibilities. Is it clear who is paying wages? Is somebody paying wages, or are the workers being retained on an independent contractor basis? You really need to spell out what your expectations or requirements are in your client service agreements. If you're the host employer, if you're the recipient organization of the worker services, you should know for risk management purposes how that other provider you've partnered with is engaging the workers that are performing services either at your work site or for the benefit of your customers. So those W-2 responsibilities need to be crystal clear in the client service agreement. Do you require insurance, business insurance, or employment practices insurance or other types of liability insurance be carried by the other party? That needs to be addressed in your client service agreement. Indemnification, what happens when there's a third party claim? Who's responsible for what? Another, we added this to the list, and we know our time is short today, but worker acknowledgments, we actually see that as an aspect of risk management that's often not addressed. Not that it absolutely has to be in every traditional temporary staffing arrangement, but it bears considering. And what we're talking about there is an acknowledgement that is received from the worker at issue on a worker-by-worker basis, in which the worker is acknowledging who is their employer, whether they have the right to participate in collective or class action lawsuits, whether they've agreed to arbitrate their employment-related claims. And the worker acknowledgement form is a key and convenient way to obtain those acknowledgments if you're going to go in that direction. And finally, reporting and cooperation. It should really be addressed in the client service agreement. And again, without that provision in your client service agreement, it can be a little more difficult to have conversations about who's handling what as it relates to reasonable accommodations, or how are investigations being handled. So the opportune time is to address that up front with your third-party providers and make sure it's addressed in your client service agreement. I'll turn things back over to Josh to talk about some of the red flags related to independent contractor misclassification.
Thanks, Mike. So Rachel was helpful in covering the policies and possible audits. Mike was talking about best practices to mitigate risk with staffing firms. And when it comes to independent contractor classification, we've got 10, we've got 5 and 5 on the slides. We've got 10 red flags that we see with IC classification. So you want to avoid these sorts of things, as they really just pop off the page to an agency or a court that you are headed down the wrong road for a misclassification. Obviously, the direction and control remains the central factor in the analysis. How much do you control the independent contractor completing their work? Controlling scheduling. If you've got somebody that you're scheduling just like employees, that's a problem. We actually find a lot of our clients are able to do a decent job when it comes to independent contractors on allowing them to control their own schedule. We find that the staffing firm situation, that's often not the case. They need people for specific shifts, but in the IC situation, allowing ICs to accept or reject work, control their own schedules, focus on the deliverables. Another red flag is if they work full-time and exclusively for you for any meaningful period of time. If they're working full-time and only for you, it's really antithetical to the idea that an independent contractor is running their own business, has their own clients in addition to you. And it's okay for a short period of time if they're working on a kind of intense deliverable, but if they're working full-time and exclusively for you for any length of time, for any longer length of time, that's going to be a problem. Independent of the full-time and exclusive, just being engaged as an independent contractor for longer than 12 months generally raises a flag. There's no bright line rule, but 12 months seems to be sort of the unofficial rule for the time where it starts to raise eyebrows. If you engage an independent contractor as both an employee and an independent contractor in the same year, you're going to be issuing a 1099 and a W-2 from the same entity in the same year. In particular, tax agencies raise an eyebrow at this and might look into it further. Additional red flags for IC classification, their services are part of your core business. So what is it that you're selling, delivering, doing? What are the services you provide? And is the independent contractor providing services sort of outside of that core business that kind of assists you to operate your business? Or are they actually providing services that are really part of your core business of what you're selling, what you're delivering, what your company does? Another red flag is if an IC is doing the same work as an employee. This is a really big red flag where you've got employees and ICs in the same positions doing the same work. They're going to be found to be misclassified. If you have extensive training and onboarding, that's an indication of significant control over how they're doing their work. It also suggests that they did not bring their independent skill set as an independent contractor, but instead, like an employee, you're training them up on how to do their job. Equipment and reimbursement. If you're providing tools, equipment, reimbursement for business expenses, this is going to raise a flag. And then a big one that we're dealing with a lot right now with our clients is if the IC does not have a business such as an LLC or other business entity, if they aren't carrying insurance and maintaining business licenses, it's really hard to satisfy that factor of them running their own independently operated business. Also, having an LLC or other business entity for the independent contractor, it just sets it up more as a business-to-business relationship where we're purchasing services, some sort of deliverable from the IC, as opposed to just sort of engaging them and paying them just to continue to work for us as an employee would, as opposed to for deliverables. So with that said, we're going to leave a couple of minutes here for the Navigator IC information for you. And I have been furiously answering questions in the chat. I'll continue to do so. And you can also reach out to Mike, Rachel, and myself after the presentation. We're happy to engage with you that way as well. So Michael, if you want to take back over for the Navigator IC information, please do.
There is so much to think about in these topics. Can you hear me?
We got you now.
Oh, okay. Sorry. I was just thanking you for the great updates and insights. There is a lot to think about when doing this. And you don't have to go it alone. The first solution that we created 8 years ago was for independent contractor classification. And not only does it have all the federal rules built into it, it also has all the state rules. And Littler looked at thousands of the cases and opinion letters, and that logic is built into the system. And what's great about it is you go and identify the jurisdiction you work in, and it will apply the rules of that jurisdiction. Not only can you go through and accurately get the information, you can even assign the questionnaire to an independent contractor so you get the right information. You know what percentage of their work comes from you and of what other places they work. And then you go through the same efficient and consistent classification steps every single time. We've broken it down into 8 different topics, whether it's financial details or work and scheduling. These are all things that will help you understand the classification for that individual. Once you hit submit, we give you a risk level on both the federal and the local risk amounts, and then we break it down. In that risk report, the first top that you can see in green here, it cites what the law is, and then underneath that we talk about your fact pattern. So we help give you insight why it's a risky position, and we have a whole transcript that goes along with it. So you can go back and rerun these if needed. When you use these type of solutions to go in and understand where your risk is, you have a significant savings in time and money, and then you can call Littler to come in and work on your most challenging positions. If you're interested in a free trial of Navigator Suite, please say yes to this poll, and someone from my team will reach out to you. We'll talk about your requirements. We'll show you how to use the solutions, and then we'll give you a free trial where you can come in here and try these yourselves. I know we're near the top of the hour, but Josh and team, did you want to answer a couple questions before we sign off?
Yeah, I think in light of the timing, I've been answering as many as I can on the chat. I think in light of the timing, we'll respect everybody's time to get out of here. But here's our contact information. You can email one of us, all 3 of us, and we're happy to engage with you for sort of a quick answer on something. We can't give legal advice unless we engage as an attorney-client relationship, but we can give these broad kind of questions some feedback to you. So thank you so much to you, Michael, and ComplianceHR for having us today. And for those who attended, thank you. We've got a lot of great questions, and we've been trying to get to as many as we can. So reach out if you have specific questions, and we look forward to seeing you at our next presentation. Thanks.